Hi, Jade. The Sixth Amendment of the U.S. Constitution guarantees the right to a trial by an impartial jury of the state and district where the crime shall have been committed. In other words, a jury of your peers. The U.S. Supreme Court took this one step further in Taylor versus Louisiana in 1975 and determined that an impartial jury may not be demographically representative of their community and therefore not composed of a fair cross section. One study found that when compared with the demographic characteristics appearing in the 2010 census, jury panels in state court in Hamilton County, Tennessee, were not representative of the citizens who live in this county. The jury panels were composed of a higher percentage of whites, males, and citizens with higher levels of education and income. In Washington, D.C., a city that is nearly 60% black, the prospective jury for the sexual assault case against a black defendant was almost 90% white. These type of differences occur all throughout the United States. Secondly, in today's complex society, a juror may not comprehend the substance of the testimony. Cases of medical malpractice, product liability, or the environment may depend on very complicated scientific issues. A jury of your peers would need to be composed of citizens comfortable with the specific issue in question. For example, a layperson will not understand the medical jargon associated with medical malpractice lawsuits and therefore may not make sense of the arguments. This was the case in the Arthur Anderson Enron obstruction of justice case, where jurors admitted they had not understood most of the government's argument. Finally, humans are subject to biases that can intrude on our judgments and decisions. In 2013, Lehman and Smith published a study that found that jurors with higher income and religiousness hold more favorable sentiments for the prosecution, while blacks tend to hold more favorable sentiments for the defense. They found that prosecuting defense attorneys can use this knowledge to manipulate trial outcomes in their favor. Jury members can also be biased due to their own values and morals. Prospective jurors might conceal information for reasons including the fear of being frowned upon. Wiley and Bottoms found that subtle anti-gay bias may lead to stereotypes such as gay men being promiscuous. A person may be aware of their personal bias but may choose not to disclose this to the judge during voir dire. Or they also may not even be aware that they have these stereotypes. All of these lead to the inability to have an impartial jury made up of your peers. Thank you.